Hi everybody, it's Andy and welcome again to my office in Los Altos, California. I'm an attorney licensed to practice law in California as well as New York. In this video I'm going to go over something called a stay of eviction as used in California landlord-tenant cases. So if you've watched any of my other landlord-tenant videos, you know that I usually give a disclaimer at the very beginning talking about how this is residential only, not commercial. If you live in a houseboat, this doesn't apply to you. If you have Section 8, this doesn't apply to you, etc., etc. So, thankfully though, for this video about stay of evictions, I don't have to give a disclaimer like that because the statute I'm going to talk about is generic. Like, it applies in landlord-tenant cases, it applies in other civil cases, etc. So, a stay of eviction, if you're not familiar with the term, basically addresses a situation like this. Imagine for a moment that a landlord and a tenant, they go to, eviction court, and after evidence is presented, witnesses testify, basically after a trial happens, the tenant loses. So in other words, the tenant has to move out. Now in California, there are a bunch of steps between trial and before the sheriff comes to remove a tenant. There are a bunch of steps that have to happen in there, but in general, like a good rule of thumb is that if stuff is done in a timely manner, the tenant usually has about a week from the time of trial to the time that they have to be out. But if you're a tenant, for example, in a situation like that, let's say that you are older or you only, you have a lot of children or something, like basically there's something that makes it impossible for you to move out in just a week. What are you as the tenant supposed to do? Do you stay and fight the sheriff? Do you, move into a shack down by the river, etc.? What do you do? Now, the stay of eviction is an option for a tenant in a situation like that, and it basically works like this. So the tenant can ask the judge, and the burden is on the tenant, to ask the judge, Judge, could you please give me an extra, 20 days, 40 days, whatever, to allow me to move out because I need more time to find a place, I have a large family, because I'm older, I can't pack up my stuff as quickly, I can't do it within a week. But I can do it within 30 days, 40 days, etc. And if the judge is convinced, the judge can order that your eviction be delayed by up to 40 days. Now, the good news, or the bad news, I guess, if you're a tenant, is that the discretion by which a judge will decide to grant or deny a stay of eviction varies tremendously. I've been in front of judges here in Santa Clara County where they grant 40-day stay of evictions automatically. Like, as long as you meet a very low threshold, you'll get the full 40 days. I've been in front of judges that are exactly the opposite, where you complete the best case possible, and you might only get 3 days, or you might only get a week or something. So it really varies, I guess, based on your luck. I guess if you're unlucky, you draw a judge that doesn't give you any more time, and you're basically stuck. But most judges I've been in front of will at least consider, a stay of eviction. If not the full 40 days, then maybe they give you 20 days, and then if you need more time, maybe you can come back, etc. So, based on that, then, the statute in question that we're talking about is California Code of Civil Procedure, Section 918, which I'll go ahead and write over here as well as paste and link down below for you, like I normally do. 918, if you read it, is... I'm not sure if the word's confusing, but like if you read it, it doesn't say 40 days. It mentions like an appeal period plus 10 days. It doesn't mention landlord-tenant law specifically. Yeah, but trust me, 918 is the actual statute that applies here. So a couple downsides, I guess, or good sides, depending on which side of the case that you're on. A 918 stay of eviction, if you are a tenant, can be granted to you for up to 40 days. 40 days is the maximum. However, you need to be able to prepay the rent for whatever time you're asking for. So if you're asking for 20 days, you literally need to have, the rent in your hand, check, cashier's check, cash, etc., and prepay that time before the judge will give you the extra time. If you are the landlord and you don't want to agree to this, can you basically refuse to cooperate, and will the judge give the extra time anyway? Unfortunately, yes. The landlord's consent is not required because the tenant has to prepay. So in the eyes of the courts, the landlord basically is protected financially because the rent has been prepaid. The good news, I guess, if there is one, from the landlord's perspective, is that the maximum time under a 918 stay of eviction is 40 days. the judge can give up to 40 days, but if the tenant still needs more time beyond that, and the landlord does not consent, can the judge give extra time beyond 40 days anyway? And the answer is no. So the maximum time without the landlord's consent is 40 days. Yeah. So hopefully that made sense. I find a lot of tenants are in situations like this where they really go, well, I can't move out in 5 days or 6 days or something. I really need more time. And the landlord basically is sick of it, I guess, for lack of a better word, and they really don't want to give more time, and they basically say, hey, I've dealt with you long enough. It's your time's up. You need to get out. A 918 stay of eviction basically is what it's designed for a situation like that. So that said, I guess if you are in a situation where you are trying to do a 918 stay of eviction, I have one kind of tidbit for you, I guess. A while ago, I put out a video on local forums, which I'll go ahead and actually link over here if you haven't seen it already. But I have 2 of them actually, and this is the second one in that series. So if you look at that one though, I go over local forums in terms of like packets of commonly asked questions, I guess. So the idea is that in a particular county, you might have a lot of requests for example, a 918 stay of eviction. So rather than kind of answer that question from scratch each time somebody asks it, the court in that county might go, hey, we'll put together a package so we can just hand it to people, when they ask for this stuff, rather than kind of, repeat ourselves, over and over again. So in Stanislaus County, California, where my office in Modesto is, they do have a 918 packet that they can, they basically have put together. And that 918 packet is available for download as a PDF from the Stanislaus County Court website. I will go ahead and link that PDF down below for you. So if you need a 918 stay of eviction, you just go ahead and look at that packet. If you are in Stanislaus County already, that packet is directly applicable to you. Like, you just print it out, you fill in the blanks, you submit it, hopefully it works for you. If you are not in Stanislaus County, but you are elsewhere in California, here's the kind of, the trick or the insight. That packet from Stanislaus County also works for you. The law that they mention, the kind of examples that they go over, that stuff is not specific to Stanislaus County. You can use it even if you're in Los Angeles County, San Diego County, Sacramento County, etc. Obviously, the one thing that you do need to change, though, is that everywhere in that packet that says Stanislaus, 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 you need to just basically delete that and make it, say Los Angeles, Santa Barbara, Santa Clara County, whatever. You do need to kind of tailor the actual text for your particular situation. But the law that they mention, the cases that they mention in that packet down there, those things apply to other counties besides Stanislaus. So hopefully that made sense. The basic takeaway from this video is, if you are a tenant who needs more time to move for whatever reason, you can do something called a 918 stay of eviction. That packet from Stanislaus County down below is going to be a good kind of starting point for you. But the thing is, the idea of the 918 stay is that you can ask for up to 40 days. You have to prepay the rent, though. But you can get the 40 days even though the landlord does not agree. Because you have to prepay the rent, there is one sort of downside here. If you are a tenant and you were evicted because you could not pay the rent, you lost your job, for example, the 918 stay of eviction is kind of a hollow right because you can't prepay the rent. Yeah. So I mean, I guess the 918 stay is not particularly useful for somebody in that situation, but hopefully, the 918 stay is useful for, other situations, maybe one that you find yourself in. So, again, hopefully that wasn't too confusing. Go ahead and like, share, comment, subscribe, all that nice stuff, and I will talk to you guys next time. Thanks.